Well, good afternoon, good morning, and good evening, everybody. I'm Paul Daly, the University Research Chair in Administrative Law and Governance at the University of Ottawa, and this is the latest installment in this year's Administrative Law and Governance Colloquium on Artificial Administration, Automation, Digitization, and Artificial Intelligence in Public Administration. And I'm very pleased to be joined today by my colleague, Dr. Teresa Scassa, Professor Scassa, who is the Canada Research Chair in Information Law and Policy at the University of Ottawa's Faculty of Law. Her current research projects include grant-funded work on digital cartography in the law, government-citizen interaction in the GeoWeb, open government and open data, and trademarks and freedom of expression. Professor Scassa holds undergraduate law degrees in civil and common law from McGill University, as well as a master's and a doctorate in law from the University of Michigan. As a researcher, she has prepared reports for the Competition Bureau and Industry Canada, the Law Commission of Canada, the Office of the Privacy Commissioner of Canada, and Health Canada. She is the author and co-author of several books, including Canadian Trademark Law and Electronic Commerce and Internet Law in Canada, which won the 2013 Walter Owen Book Prize. She is a past member of the External Advisory Committee of the Office of the Privacy Commissioner of Canada and of the Canadian Government Advisory Committee on Open Government. She's a member of the GeoThink Research Partnership and has written widely in the areas of intellectual property law, law and technology, and privacy. Lastly, she is a co-founder and former editor of the Canadian Journal of Law and Technology. Accordingly, it's hard to think of anyone better placed to speak to us about administrative law and the governance of automated decision-making based on her excellent recent article on the Directive on Automated Decision-Making published in the University of British Columbia Law Review. Professor Scassa, Teresa, thank you for being with us, and the floor is yours.
Thank you so much, Paul. And it's a real pleasure to be invited to be part of this colloquium. Really excellent lineup of speakers on automated decision-making or automated administrative law. And so I'm very much happy to be part of that. And although I've been teaching law and technology for years and researching in the area for years, I did start out my career early on teaching administrative law and enjoyed it very much. And so when I started looking at at Canada's Directive on Automated Decision-Making early on, I approached it thinking in terms of AI and AI governance, and became very interested in the administrative law dimensions of this tool that I'll be talking about today. I just have to figure out how to, oh, look at that. I managed to control my slides. All right, so the way in which Professor Daly has structured this colloquium, my talk falls into a part or a section that looks at soft law, and the Directive on Automated Decision-Making is certainly a soft law example of AI regulation or governance for automated decision-making. This is a useful tool that can be used to shape the adoption and implementation of automated decision-making. And as I'll talk about it, you'll see how the tool aims to build into government automated decision-making safeguards to ensure that the process is fair and appropriate and the technology is designed appropriately, certain transparency mechanisms, as well as principles of fairness. And so one of the questions that I'm interested in my research is how these forms of governance of automated decision-making draw upon, inform, or transform principles of administrative law. So it's not just, how does it regulate AI in government and automated decision-making, but it's also what impact does this tool have on administrative law, and what impact does administrative law have on this tool? And I think that the focus on administrative law is particularly interesting here because certainly in Canada, this is an under-regulated area. And I'll talk a little bit more in more detail later on about just how inadequate the current laws are in Canada for governing artificial intelligence and automated decision-making, if we're thinking about privacy law or specific laws aimed at automated decision-making, there really is there's been a dearth of lawmaking. And so there's a gap on the enforcement side. And so administrative law can play a significant role in this context. So a little bit of background about the DADM. In 2017, three individuals, Michael Carlin, Ashley Casavan, and Noel Corriveau, wrote a white paper on responsible AI in the federal government and set out 7 principles to govern AI and automated decision-making. Michael Carlin then led the initiative to draft the Directive on Automated Decision-Making and the accompanying algorithmic impact assessment tool. And this was done through an open and collaborative process. So it was a very interesting process where drafts were published on GitHub, input was solicited, people made comments. And so it was a public and iterative process to develop these documents. And so the process itself, the history of the development of the DADM is interesting. It took effect on April 1st, 2019, with compliance required by April 1st, 2020. It also provides that it's subject to reviews at 6-month intervals. And so there have already been reviews of the DADM with recommendations for changes. And there have been some changes made to the DADM with those last amendments being made April 1st, 2021. Just going to situate it a little bit in a broader Canadian context in terms of what else has been going on in Canada. The province of Quebec recently introduced its strategy for integrating AI in public administration. You'll notice on my slides I have lots of links. And in case you're sitting there thinking, does she not realize that we can't click on these links? I do realize that, but I am very happy to share my slides. So if you want a copy of my slides, you can just contact me later, or I can make them available through Professor Daly. So Quebec introduced this strategy, which is, again, there's not a lot of hard principles or actual tools in there. This is setting the groundwork, laying the groundwork, the strategy for integrating automated decision-making. So setting out what the principles are, what the concerns are, and that sort of thing. But at the same time, Quebec has also done something which other provinces in the federal government have been slow to do. In Bill 64, which passed into law in September 2021, it introduced some new legal rules for public and private sector automated decision-making, at least as they relate to the use of personal data. And so you have the beginnings of actual legislative rules around automated decision-making in the provisions of Bill 64, which are being phased in over the next couple of years. Ontario is also in the process of developing principles for ethical AI in government as a first step on the way to then developing some kind of policy framework or guidance, perhaps something similar to the DADM for to govern the adoption of AI in government. We also very recently saw Toronto Police Services issued a new policy on the use of artificial intelligence technology in policing. Now, they did this in part in response to the Clearview AI scandal, where it was revealed that officers within the Toronto Police Services had used Clearview AI, obviously very significant problems with that on all kinds of levels. And so the TPS engaged in a public consultation and drafted a policy which has just been adopted, which governs how AI technologies will be adopted and implemented within the Toronto Police Service. So it's another interesting example of this kind of policy. A couple of other things that might be interesting if you're interested in this area, that work that's been ongoing by the Law Commission of Ontario. They have produced a paper regulating AI critical issues and choices, which does deal with public sector use of artificial intelligence. And they have a forthcoming paper, which is specifically on AI, ADM, and government decision-making, which should be coming out this spring. So in the next couple of months, expect to see that. But the Law Commission of Ontario has been doing some really interesting, detailed, thoughtful work in this area. And the BC Office of the Information and Privacy Commissioner has also issued a paper on meeting the challenges to privacy and fairness arising from the use of artificial intelligence in the public sector. And I flagged that this is the BC Office of the Information and Privacy Commissioner. So in a sense, their mandate is privacy and data protection, and not AI specifically. Obviously, there's a big connection between AI and data protection. But I think it's significant that you have the OIPC issuing this document, which does address automated decision-making beyond, issues that go beyond privacy. And I think it's indicative of the fact that we're in a context where we don't have oversight bodies specifically charged with oversight, for example, of AI technologies, and we don't have regulations and so on governing AI. And so you see privacy commissioners essentially stepping up to fill in gaps using their mandate relating to data. So some of the challenges with automated decision-making in government include obviously the need for high quality interoperable data. Now, if you're talking about public sector automated decision-making, on the one hand, you can say, well, this is the government administrative data that government has collected, and so government has access to that data. That's true. That data may not be as high quality as it needs to be, but it also is not necessarily the only source of data. And so data may be combined from multiple sources. There are also issues in terms of the ability to share data horizontally across government, because again, data protection laws are largely out of date and are built on a framework where vertical data silos was considered to be the best way to protect privacy, and horizontal data sharing was seen to be problematic to protecting privacy, whereas of course to do AI in government you need horizontal data sharing. So there are issues around data in the public sector context. Obviously, there are privacy risks, not just with respect to government stores of private data, but also if you're thinking about implementing AI and automated decision-making and communication back and forth between citizen and government, there can also be privacy issues that arise in that context. Risks of bias and discrimination have received a great deal of attention, and so they should. In automated decision-making, unintended consequences as well. You set up a program to serve particular public policy goals, and through just the course of the functioning of the algorithm, perhaps your outputs take you in a different direction. So unintended consequences are an issue as well. Trust is a huge issue for government, and for government in general these days. But with artificial intelligence in particular, trust is an important issue. I could have added to the trust bullet, public engagement and consultation, and those are often issues that are raised at the same time as trust. Transparency is a big issue. And of course, oversight, recourse, and accountability are all important issues. And and again, I'm going to keep coming back to this because this is ultimately what provides the foundation, the bedrock, the protection for the public, is having some form of recourse when things don't go as they should. So I want to raise the issue of automated decision-making as more than just a tool for reaching decisions in government. And so I want to set it in some kind of context and maybe just suggest here or prompt the thinking here about these quantum shifts, or these major shifts that have taken place in administrative law. And so the rise of the modern administrative state has been described as one that shifted away from legal formalism, where the focus was on legal rules, authoritative documents, scientific decision-making processes, towards policy-based decision-making. So at a certain point, policy became more important than the formal legal rules. I'm not saying the formal legal rules are not important, but the focus or the orientation shifted towards policy. And so one of the interesting issues in this context, I think, is whether automated decision-making is actually a return to a kind of legal formalism, because if you are going to write an algorithm that incorporates the rules for a particular decision, then you are giving a certain preeminence to the rules. And here I want to flag a wonderful paper written by Jennifer Razzo, who's a professor at the University of Alberta, who works in the area of administrative law and AI. And she wrote a paper that explored the resistance of frontline social workers in Ontario to outcomes of automated decision-making. So they were given an automated decision-making tool to replace decisions that to perform the decisions that they used to make, and they had to oversee essentially the input of data from clients into this tool that would produce outcomes. And what she documents and writes about is how they began to experience many of these outcomes as unfair or inappropriate in the context of those particular clients, and how they began to game the algorithms, understanding what data you needed to put in to get a particular result, thinking about the result that they thought was fair and appropriate, and then inputting the data accordingly. And so I think that's really interesting. It's an interesting piece of research. It's interesting in this context where you have to think about what, ADM is more than just a tool. And so what are the ideological implications of instituting automated decision-making when it comes to administrative decision-making? There are a number of different rationales that are proposed for the adoption of AI in the public sector. We frequently hear about greater accuracy, efficiency, and fairness in decision-making. So there are, and efficiency, frankly, is a big one. So we hear a lot about improved decision-making through greater efficiency. The OECD, which has written a report on the issue, talks about the ability to use AI to provide more personalized services, to foster citizen engagement with public institutions, with human-centric interfaces, greater operational efficiency. Now, what the OECD is describing here is not just automated decision-making, but it's also the use of AI in a whole broad spectrum of ways within the public service. And I think that's interesting too. I'll talk in a minute about the fairly limited scope of the directive on automated decision-making in comparison with the broad range of things that can be done with AI in the public service. So they talk about greater predictive capabilities and so on. So there's this whole spectrum of things that AI can be used for in the public service. And there's the suggestion as well that governments need to deliver the same levels of responsiveness and personalization as are available in private sector services. So just as Alexa or Siri can anticipate our needs and wants, so too perhaps should the government be able to anticipate our needs and wants and personalized services to us. And I think this is an interesting question, and someone like Amanda Clark, who's an academic at Carleton University who does research on public administration. I'm hoping I'm not putting words in her mouth, but she might actually question whether this is in fact what people are wanting and expecting from digital government. Government has also, and I think it's important to keep this in mind, has also heavily invested in AI and the innovation economy. And not just the federal government, some provincial governments as well have done this. So they have a stake in this. They want to see AI industries thrive in Canada and AI innovation thrive. And so there may also be a motivation to adopt automated decision-making systems and other forms of AI in government as part of just buying into, stimulating, supporting the growth of this industry in Canada. There are many questions that arise in the decision, when the decision is made to implement automated decision-making in government. Obviously, the goals and objectives, why you're doing it, are important questions to consider. What's the underlying motivation for doing this? The scope of application is also interesting. What types of decisions will automated decision-making governance apply to? I'm going to talk a little bit more about that in the context of the ADM. Will a policy like this be grandparented? In other words, is it going to apply to existing systems? Will they be subject to review under this or only to new systems? What type of enforcement should there be and accountability? What type of oversight and review? And what kinds of features and principles should guide the tool? In terms of the DADM, it describes some of its objectives as reducing risks to Canadians and federal institutions when automated decision systems are deployed. So the assumption there is that they're going to be deployed, and so the goal is to reduce risk when they're deployed. to support more efficient, and there you see the word efficient again, accurate, consistent, and interpretable decisions made pursuant to Canadian law. And here I note the absence of adjectives like fair, transparent, or accountable. I don't want to be mean, right? Because the other, but I think it is interesting that they're not there. Fairness is described as an expected result, not as a goal of the DADM. Other expected results are ongoing assessment of impacts of algorithms in ADM and a certain level of transparency with respect to automated decision systems. The DADM, the decision was made that the DADM would be prospective, so no grandparenting. Any automated decision systems that were already in place would not be subject to the DADM, only those that were newly commissioned. The decision was also made that it would only apply to automated decision systems that provide external services. Now, on the one hand, you can think about this as a go slow approach in the sense that you develop this policy, you got to, work out the kinks, get it in place, get it implemented, and maybe you carve out a narrower scope of application. But I think that it's still important to think about that scope of application. So external means that the intended recipient is a client external to the Government of Canada, so somebody who's not part of the Government of Canada. And the service is the provision of a specific final output that addresses one or more needs of an intended recipient and contributes to the achievement of an outcome. And so there are some things that clearly fall within scope, and then there are some things that clearly fall without scope, and then there are gray areas. And so, for example, I raised the question of whether this scope would capture a fraud detection algorithm that identifies likely candidates for investigation or audit. And my sense is that it would not, that this description doesn't capture that type of use of artificial intelligence. And I think that's interesting and potentially problematic. Again, keeping in mind that this may have been a go slow approach. Hiring, employee management, and employee evaluation, use of AI in those contexts are clearly out of scope. This is just a copy of a headline from the Globe and Mail from just over a year ago about how national defense skirted federal rules in using artificial intelligence, according to the Privacy Commissioner. This was a story, I don't know if you noticed it in the news at the time. The Department of National Defense hired an external company to provide to run a hiring process using artificial intelligence. So it was an artificial intelligence enabled hiring process put in place by the Department of National Defense, and they did not follow the DADM or conduct an algorithmic impact assessment. And at the time, there was this, concern that they were not following these rules that were put in place. I'm going to come back to the Privacy Commissioner part in a few slides, but that they hadn't done this. And frankly, the reason why they hadn't done this is because it's for external services, right? And there's some question about whether hiring people from the outside is external service or not. But in any event, there is that issue about external services and as being within the scope of application and internal employee-oriented, not. Now, the third review of the DADM specifically recommends expanding its scope to cover internal uses of automated decision systems, including those that impact federal employees. And so I quote from there, the directive was not designed to address AI risks impacting individuals within the federal public service. This is proving to be a limitation that risks damaging public trust in the government's capacity to strike an appropriate balance between innovation and responsibility. And I agree with that, and I think it's a good recommendation. So it remains to be seen when it will be adopted, if it will be adopted, when and how it will be adopted. But certainly there's a case that can be made for expanding the scope of the DADM to cover employees. And I think, I'd like to say coming out of the pandemic, but who knows if we are actually coming out of the pandemic. We're certainly acting as if we are coming out of the pandemic, let's just say. Coming out of a couple of years of pandemic where more and more people have worked from home, and there has been a steep rise in the use of electronic monitoring and other sorts of remote surveillance technologies in a variety of different workplaces, the prevalence and use of artificial intelligence to monitor employees, to evaluate them, to conduct performance evaluations, to do all sorts of things related to employment, to use the AI in hiring processes and so on. It's quite significant, and so it is a major gap. In terms of the enforcement or accountability and the ADM, it is a Treasury, the DADM is a Treasury Board directive. It's the Directive on Automated Decision Making. And directives are formal instructions that oblige government departments to take or avoid specific action. Another feature in this directive is that it invites qualified AI vendors to make a public pledge to work only with those departments that have completed an AIA. So you'll see there in that public pledge the weakness of the directive in terms of its enforceability, accountability, but at the same time, you can also see the attempt to use the directive to influence industry to engage in development of artificial intelligence solutions in a way that is compliant with the DADM. So to provide some sort of incentive for industry to act according to the norms expressed in the DADM. And the requirements otherwise within the directive are the same as you'd find in any directive. They're internal to government. The sanctions are internal to government, and there are no actionable rights for individuals or organizations. So the DADM sets out all of these rules and this framework for AI governance, but individuals who feel that they have been shortchanged in an automated decision-making process do not have any kind of direct enforcement right. Now, back to the DADM enforcement and oversight, and here's the headline again, where I've underlined the Privacy Commissioner. The Privacy Commissioner has no, in the Privacy Act, which would be the applicable legislation here, has no specific authority over artificial intelligence. And in fact, the rules that were skirted here related to the use of personal data and the need to conduct a privacy impact assessment. And so if you read beyond the headline, of course, that's the concern of the Privacy Commissioner, that the DND did not conduct a privacy impact assessment before outsourcing this hiring process to the company it outsourced it to. But there isn't actually any review of the, since there's no formal legal obligation to use the DADM and the algorithmic impact assessment tool or to carry out an algorithmic impact assessment. This is not the shortcoming in this particular case. It was the failure to conduct a privacy impact assessment. And again, I just want to underline here that this issue of oversight and enforcement is a tremendously important one, right? That it creates a real gap in the structure and the framework, in my view. In terms of transparency in the DADM, the DADM requires that plain language notice be provided on relevant websites that a decision was made in whole or in part by an automated decision system. So there should be some form of notice to individuals about the use of automated decision systems in reaching a decision. Individuals also must receive a meaningful explanation of how and why the decision was made. Recent recommendations as part of the review of the DADM are to amend the directive to clarify that a meaningful explanation is one that is interpretable to users and clients. And in procurement for transparency purposes, the government has to retain the right to authorize third parties to review or audit software or its components, and must retain a right to access and test the ADS and all released versions of software components if it's necessary for an investigation, inspection, examination, enforcement action, or judicial proceedings. So there are a number of provisions in the DADM that require elements of transparency to be incorporated into the design and adoption of automated decision systems. Quality assurance is another element of the DADM, which can require testing of ADS for unintended data biases and other factors that may unfairly impact the outcomes. And again, to note, the review report in 2021 recommends testing for model bias and not just data bias. So initially it just referred to data bias, and the recognition is made that it should also be, there should also be an obligation to look at model bias. And I'm adding these bits about the review because I think that's important. I think it's important that these recommendations have been made, but also that there is this review, this iterative review process to continue addressing any shortcomings in the directive and to improve it. The review of ADS should be by qualified experts, and data used in the ADS must be relevant, accurate, up-to-date, and compliant with privacy legislation. So those are some of the quality assurance dimensions of the DADM. The DADM also provides for a role for human intervention, although whether there is such a role depends on the nature and impact of the decisions being automated. And it's a risk-oriented framework, and I'll talk a bit more about that in a minute. Affected individuals and organizations should also know of any recourse options to challenge decisions, which can include challenge through judicial review. But there is this recognition that in some cases the human in the loop has a role to play. And I won't get into it now, but in other work that I've been doing on artificial intelligence, I've become quite interested in the human in the loop and how the human in the loop is seen as in a sense a safeguard or saving mechanism for AI applications that could have significant impacts. And I've encountered some pretty significant problems with the human in the loop in those contexts. Happy to talk about that later, but in any event, there is a human in the loop element to this. The DADM also comes with the Algorithmic Impact Assessment tool, the AIA tool. And this is structured as an electronic survey. It's an algorithm. It collects data, it gives the data certain weight, and it produces or generates a score, a risk score. And then based on the risk score of what is being proposed, of the algorithm proposed, it indicates what measures from the DADM have to be complied with. Because as I mentioned before, it's a risk framework for the DADM. So depending on whether something is low risk or low impact or medium impact or high impact, the obligations will be different. And so you do the electronic survey, it gives weight to certain answers, it produces a score with the obligations that have to be complied with. And so it is mandatory, at least in the terms of the directive, to complete an AIA prior to the production of any automated decision system covered by the policy. It also has to be renewed, the algorithmic impact assessment, if there's any changes to the automated decision-making system over time. And the final results of an AIA have to be publicly released under the Directive on Open Government, subject to certain restrictions if there's any confidential information or other things that shouldn't be released openly. And if you look, if you follow have the opportunity to follow the link that I provided in the slide, or if you look at the Open Government portal, you'll see that 3 AIAs have now been published. At the time the national defense story broke a year ago, only 1 AIA had been published, and they're now up to 3. Information on the effectiveness and efficiency of the system must also be published on a government website. So there are these transparency requirements that are also built into the AIA. So the governance and accountability mechanisms in the DADM depend on risk and the degree of procedural fairness that the law requires for any given decision-making process increases or decreases with the significance of that decision and its impact on rights and interests. And here you can see that the DADM is really borrowing administrative law language, right? The degree of procedural fairness. So procedural fairness is administrative law language. And the degree or the duty of fairness that's owed is going to depend upon the significance of the decision and its impact on rights and interests. And the AIA is the tool that's used to help to calculate the significance of that decision and its impact. The AIA uses a series of questions that need to be answered, and I'm just giving you a sample of some of the questions. It's a long survey Will it use personal information as input data? Will it use data from multiple sources? It also asks questions, how long will impacts from the decision last? What will the impacts the decision will have on the rights or freedoms of individuals will likely be, and you have to, the person answering this has to explain what those impacts will likely be, and provide a description of why the impacts resulting from the decision are as assessed above. So there has to be some explanation of why that calculation was arrived at. So those are the kinds of questions that are asked. So they're not all yes or no questions. Some of them require discussion or description. In terms of the risk assessment, the relevant impacts to consider are risks to the rights of individuals or communities, risks to the health or well-being of individuals or communities. And so you notice here that it's not just individuals, but it can be communities as well. So it's a recognition of how decision-making can affect groups or communities and not just individuals. On the economic interests of individuals, entities, or communities, so business interests can be impacted here, and on the ongoing sustainability of an ecosystem. Presumably that doesn't include the impact that using artificial intelligence has on the environment. Just throw that out there because some say it has an enormous impact, but it's the decision-making, the impact that the decision-making has on the ongoing sustainability of the ecosystem. And there are 4 categories of impacts. Little or no impact, which is described as an impact that is reversible and brief, likely to have moderate impacts, that they're likely reversible and short term, likely to have high impacts, difficult to reverse and ongoing, and likely to have very high impacts, irreversible and perpetual. Okay, so those are the impacts, the kinds of impacts and the degree of impact that form part of the risk assessment in the DADM. There's a sliding scale of obligations, and those the intensity of those obligations will depend upon the level of risk that's identified. I've put a line between 2 categories of obligations. This is really the list of the obligations in the DADM, but some of those obligations are internal within the department or agency, and some of them are directed towards the public. So and protecting the public. So depending on the level of risk identified, there may be a peer review requirement, a requirement for the system to be peer reviewed, and the number of reviewers and the backgrounds of reviewers will change depending on the intensity of the impact. There are notice requirements depending on the level of risk identified. Depending again on the level of risk, there may be a requirement for a human in the loop. And the right to explanation, which can vary according to the level of risk. Internal or training requirements for training of staff. And again, the frequency, depending on the impact, maybe it's one-off training or maybe it's regular repeated training. Contingency planning, what happens if the system becomes unavailable? What's the backup? What's the backup plan? And is approval needed for the system to operate? And so just for an example of something, if something is scored as having little or no impact, reversible and brief, then the only requirement from that list is for a meaningful explanation for common decision results. Okay, so that's not a meaningful explanation for each decision that's reached. You're not obligated to provide reasons to each individual, but to just provide a meaningful explanation of how the system works, how it reaches its decisions, and that can be provided in FAQs on a website. Okay, so I mean, if you compare it to administrative law, though, the reason, the right to reasons, meaningful explanation or right to reasons, is not an absolute right, and it will vary with the nature of the decision being made. So in a sense, it maps onto administrative law fairness principles. In terms of the decision maker, in administrative law, the decision has to be made by the person who is charged with making it. There should be no improper delegation. And so one of the questions I think that arises in the context of automated decision-making is whether the enabling legislation with respect to that particular decision, so the legislation that enables the making of that particular decision, designates a human decision maker, whether it's an individual or a panel. And if so, then they have to make the decision, even though the decision may be informed by an automated decision system. So you can have a decision that is made by a machine, but if the legislation specifies human decision makers, then your ADS may assist in the decision-making process, but the decision still has to be made by a human being. But interestingly, the DADM defines an ADS as any technology that either assists or replaces the judgment of human decision makers. So in my paper, I just flagged this delegation issue and raised the issue of whether, depending on how far the government decides to go with automated decision making, whether some statutes might need to be amended to actually accommodate automated decision making. Decision makers, of course, in administrative law are intended to be independent and impartial. Independent means free from inappropriate interference or influence. And I think that this is an interesting issue to think about in the context of automated decision-making, where an ADS, an automated decision system, is procured by government according to its specifications and is capable of being tweaked or modified. And so how do you think about the independence of a decision maker in a context where the decision maker is software that's been procured according to the government specifications? Well, just put that question out there, and I think it's an interesting one in terms of independence. In terms of impartiality, impartiality requires a decision maker who listens to both sides and is not influenced by extraneous considerations. One of the issues that gets frequently raised in the context of automated decision making is, of course, automation bias. Now, here we'd be talking about not decisions that are made by machines, but perhaps decisions that are assisted by machines. So, for example, systems that review large volumes of evidence, or that review documentation, produce assessments or evaluations of certain written text, text analysis, and so on, in order to assist the decision maker. And I think that there are interesting questions here, and I'm just noting there was a very interesting decision by the Supreme Court of Canada in 2018, Ewart in Canada, and I've written about it before in other contexts. There's a lot, I think, in that case that's relevant to automated decision-making and administrative fairness. But there's one argument that the Crown made that is discussed in this case that I think is really interesting to reflect on when it comes to this question of impartiality in the context of automated decision systems. And here the Crown argued that the information that had been derived from actuarial risk assessment tools is objective and thus mitigates against bias in subjective clinical assessments. And so the Crown was arguing that the argument that these tools were biased was problematic because the information derived from them is objective. And this is, I think, frankly, is an example of automation bias, right? It's the belief that if a machine runs the calculations and produces an output, then you've got an objective output. Whereas if a human, does the same thing, you've got an output that's subject to bias. And of course, that forgets the fact that it's a human that coded the machine, or that wrote the code for the machine, and may have embedded human assumptions and used data that itself was incomplete or inadequate or reflecting bias. So anyway, these are interesting questions that arise in the context of independence and impartiality in automated decision systems. One of the asserted benefits of automated decision-making is that it will provide more consistent decision-making. And so the question that I would raise here from an administrative law perspective is, if you have a system that pushes decision makers towards particular outcomes, if consistency becomes a value of the system, then are you going to have this push or pressure towards making outcomes that are consistent one with the other? Does that create its own form of bias, right? Is the understanding that we're all just numbers, and if you do the calculation, you're going to get the right result, and that should be your consistent outcome, as opposed to decisions that involve a little bit more discretion or consideration of circumstances. And this is, again, I go back to Jennifer Raza's really interesting paper about social workers. Is this a form of bias itself? If an automated decision system leads decision makers to focus on factors and considerations other than those before them, is there also bias? So again, this is a form of automation bias, but how do you factor this into understanding apprehension of bias in the context of automated decision making? And of course, biases can also be introduced by biased data and biased algorithms. And the DADM requires peer review of moderate to high risk systems, and requires testing for unintended bias and monitoring of outcomes of ADS for decisions with all levels of impact. And I do find that this element, the requirement that outcomes be monitored, is an interesting and significant one. It's not something we do generally with the outcomes of administrative decision making now to see whether overall there's a particular bias or slant in the outcomes. And so assessing outcomes could be an interesting way to monitor that. In terms of notice requirements, in admin law, notice is required if a decision will impact on an individual's rights or interests. The DADM requires additional notice where a decision will be undertaken in whole or in part by an ADS. And there's a sliding scale of obligation with no individual notice for low impact, plain language notice on the website for moderate impact, and more intense obligations for high or very high impact decisions, including results of reviews or audits of the system, descriptions of or access to anonymized training data, and so on. So the notice requirements, again, in the DADM are on this sliding scale that maps on to some extent to what we see in administrative law. In terms of process rights and the rights to be heard, again, in administrative law, the right to a hearing does depend on the impact on rights or interests, and we see this mapped onto the DADM with the right to a hearing translating into the right to human involvement, but again, on this sliding scale with no human in the loop for low to moderate impact level decisions, but with higher impact decisions requiring specific human intervention points in the process and a final decision made by a human. In terms of right to reasons, the right to reasons in administrative law, that again is on a sliding scale. We see the same thing in the DADM. The lowest level of impact of decisions in the DADM require a meaningful explanation for common decision results. At the second level, reasons can be provided on request. And for the third or fourth levels, there has to be a meaningful explanation of the decision. I think there's an interesting issue or question here about the distinction between a right to an explanation and a right to reasons. The duty to give reasons in admin law requires the human decision maker to explain why they reached their decision. And that can include the things that influence them personally. And that can be things like credibility of witnesses, matters of public policy. There can be a range of things that influenced or shaped how the decision was reached by the human decision maker. A right to an explanation focuses on the how of the decision. What was the automated decision system? What data was used? How was the data weighted in the system? But the DADM does refer to providing a meaningful explanation to affected individuals of how and why the decision was made. And assuming there's a human in the loop, then that may also include, for example, not just an explanation of the ADS, but then of how the human decision maker took into account the data produced by the ADS in reaching their decision. And Another interesting issue I wanted to raise with respect to the directive on automated decision making was the whose rights or interests. In administrative law, duties are owed to the person about whom a decision is made. The DADM, as I showed you before, refers to impacts on rights, on health and well-being, on economic interests of individuals, entities, and communities. And so, and also on the ecosystem more broadly. And so I think that that may raise some interesting questions about who has a right of review with respect to those decisions, or a right to an explanation or right to reasons. So for example, just to give one example, a decision on parole arguably impacts other members of the community and not just the person who's being paroled. If this is part of an automated decision-making system, who has the right to an explanation in that context? Certainly the person whose immediate rights or interests are affected, but it, you know, in the framework of the DADM and in the context of automated decision-making, are there rights elsewhere, located elsewhere as well? And so with automated decision systems, some of the issues are decision specific, so the particular facts relating to a specific individual, but some may be about how the system was designed and deployed and how it operates. And so I think one question to ask here is whether in administrative law, a new collective duty of fairness might emerge with respect to automated decision systems. So some concluding thoughts on the DADM. Is the DADM a kind of procedural fairness by design? I've underlined that and provided a link to a document that was produced by provincial and territorial commissioners, privacy commissioners on fairness by design, designing administrative systems to be fair, not specifically automated ones, but the question here is this a kind of, is this an attempt to incorporate a fair administrative decision-making by design in the context of ADM? For courts who sit in judicial review, they will obviously need to think about how administrative law principles should be adapted to the context of ADM, but should also be thinking about how code, procurement, and practice already shape and influence those principles. Are the principles that are incorporated into the DADM, do they start to codify or give shape to what the judicial review principles should be in terms of what can be expected in terms of certain intensities of rights and obligations at certain stages or in certain kinds of decision making? So how does that process work back and forth between the two? The DADM and the AIA can impact how administrative decision-making takes place and therefore can have an impact on procedural fairness, as well as how it's internalized in the common law. And I'm just going to end with the appeal for legal infrastructure for accountability and oversight remaining essential. We have privacy laws at the federal and provincial level that have not been, and public and private sectors as well, that have not been adapted to the artificial intelligence context, with the exception of the law in Quebec. We have a lack of specific legal principles, legal or laws relating to AI and automated decision-making and AI governance. We have privacy commissioners who have been doing their best to address artificial intelligence through what provisions exist in existing privacy legislation. We have human rights commissions that have legislation that's not adapted to dealing with discrimination and artificial intelligence. So there's a lot of work to do to create the legal infrastructure that can provide adequate accountability and oversight in automated decision making. So I'll just end there, and I'll stop the sharing, and I look forward to any questions you might have.
Well, thank you so much, Teresa, for that comprehensive overview of the directive on automated decision making, such an important tool, as you note, really the only comprehensive general framework for regulation of AI use in Canadian government at the moment. If you have any questions for Professor Scassa, you can pop them in the the Q&A box. I can see a few in the chat. It's a little bit easier for me to manage if it's in the Q&A box, but I'll get to those in the chat also. So the first question in the chat for you, Teresa, is from Natalie Heisler, who asks if you could comment on the limitation on the requirement for an explanation in the directive. Meaningful explanation is provided with any decision that resulted in the denial of a benefit, a service, or other regulatory action. Why only in the denial scenario, she asks.
Yeah, I think that it's an interesting question. I think that the answer is that the assumption is that if the requested benefit or service is granted, then the individual has no interest in seeking judicial review or challenging the decision. They got what they wanted and they're going to be satisfied. And so there simply isn't any reason or basis on which to challenge it. And so no need to provide an explanation. So I suspect that's the reason, although, I mean, it's an interesting point that well, I suppose if it went to judicial, yeah, so it doesn't go to judicial review, so there's no necessity for an explanation. That would be my read of the situation.
Well, that's certainly the way I read it as well. I guess the question, the next question then is, are we stuck in a logic, in sort of a defensive posture where we're looking at explanations in the context of denials? You know, we're establishing floors rather than ceilings. And maybe, I mean, one of the advantages of policies and soft law is that you can go over and above the bare legal minimums. And so I think the spirit of the question is why not impose these requirements even in cases where benefits are being granted in the hope that this would improve the technology and explainability, interpretability, and so on.
Yeah, and I think that's a very interesting, I think it's a very interesting point, because it might actually have that effect. I mean, there's the explanation is provided. It doesn't say it's published either, right? So this is the letter that the person gets with respect to their benefits. So it's not a published decision. And so it's not clear either how public or recorded any of these explanations are at that particular stage either, in terms of providing any kind of basis for researchers to go in and look at those sorts of things.
And that's a nice segue to the next question in the list, which is from Justin Lee, who asks, at a minimum, what information should be recorded for each automated decision to ensure auditability or explainability, as the case may be. Practical advice for those working in government and using automated technologies.
Yeah, certainly there are there would be requirements about what data are used in the decision-making process, and certainly, for example, if you look at the Bill 64, the Quebec legislation that just passed with respect to the public sector, there they've created an actual right to an explanation of automated decision-making in the public sector context. And if I recall correctly, part of what they require is an explanation of what the personal data was on which the decision was made. And so there has to be documentation, and has to be available to the individual to know what personal information the decision was based on, and they have to have a right to correct that information if they feel the information was that was relied upon was incorrect. So so certainly obligations in terms of what data inputs are would be important in terms of that. Beyond that, I think it might vary considerably from one system to another and one type of decision to another. I'd have to think about it a little bit more to give a better answer to that.
Right. Okay. From Amy Iaria, there is a question as to whether you know of any examples of federal procurements for external services where the RFP documentation requests bid responses to include information required for an algorithmic impact assessment. In other words, where the choice of vendor will be impacted by a lower risk score. I suppose the question there is, how are we structuring federal procurement to make sure that algorithmic impact assessments are actually a meaningful consideration in the procurement process? Of course, they may not be. The answer may be, I don't have any examples.
Yeah, I haven't looked closely at the procurement side. I know that there is a list of approved suppliers, so suppliers that have made commitments with respect to the Directive on Automated Decision-Making in the AIA. And so that you can find on the website associated with the DADM, you can find a list of approved suppliers. So I do think there is a genuine effort that's being made to align the content of the DADM with suppliers who are willing to buy into some of those requirements. And there's something, it does get complicated there because of course some of the transparency requirements and transparency issues are quite important, that if you don't have a supplier that understands the obligations with respect to transparency for the automated decision making, then you may really run into some significant conflicts. So there is an attempt, I think, to shape procurement through the DADM. How well that works, though, is an open question. And of course, the scope of the DADM is important as well. One of the things that happened with the Department of National Defense issue, when it came out in the media, there was a bit of back and forth between people at the Department of Defense and other officials in government as to whether the DADM applied in that situation. Personally, I don't think it did, having, based on my reading of the DADM, I don't think it did. I don't think DND thought it did. I think some other people in government thought it should have applied or may have applied, but in any event, it wasn't relied on. And so I think that those issues of scope and application are also really important in this context as well, because if you can find loopholes to get around the interpretive loopholes to get around the application of the DADM, then there isn't anything else. And maybe I didn't put enough emphasis on that, but you've got the DADM and it's great within the sphere within which it works. But if it doesn't apply to something, then there aren't any rules or guidelines other than just the general directives.
We really are in, in uncharted territory, certainly unregulated territory at that point, and certainly in those scenarios, not clear that judicial review would be available either. The questions are flooding in. So one is from an anonymous attendee, which and I think you'd appreciate why that is when you hear the question. And the question is about the use by Immigration, Refugees and Citizenship Canada of automated decision making. The questioner says this use has been criticized, especially for temporary residence applications, tourist visas, study permits, and work permits, which are almost entirely discretionary. I think you're being asked for your view on that, and also whether the Directive on Automated Decision Making applies to Immigration, Refugee, Citizenship Canada. I think the answer to that question is yes. I think their use of AI and automation in the temporary visa context, temporary resident permit context, was subject to the DADM. But anyway, what do you think, Teresa?
Well, I mean, for that, I think the grandparenting is a big issue, because if these systems were already under development and in place prior to the coming into effect of the DADM, it won't apply to them. And some of them may have been. Certainly the three AIAs that I looked at, none of them had to do with these services. So there haven't been AIAs done, or if they have been done, they haven't been published. But I suspect that in that case, it's a grandparenting issue, and that they were already in the system or in process before the DADM came into effect. And somebody can correct me on that if there's anyone on from IRCC and they have that information. But I suspect that that was the case there. And so again, that's another issue about the scope of the DADM, right? Now, going forward, it's going to catch a lot more as new things start up. But there's this whole question of what existed before and what other systems were in place before. One of the issues in this context, which I think is really important, is in terms of transparency, is also kind of the creation of an AI register. It would be really good if there were some kind of centralized public register of the types of systems that are already in place and being used by governments, so that so that you could at least get an overview or snapshot of all that is being used and all that's out there. And we don't have that kind of thing yet. And again, over time with the DADM, it may be that you're going to get, lots of AIAs published and lots of information available, but we don't have that grandparent information.
The part of the issue here might be that there's so much that Immigration, Refugees and Citizenship Canada does. So there's another questioner, David Chalk, who says they've been using systems such as Chinook, which they claim are not subject to the directive because they essentially filter and organize the information that's presented to a migration officer without making a final decision on an application. So it's filtering, it's upstream, therefore it wouldn't be, it's not caught by the directive. David Chalk goes on to say that the filtering itself is the cause of many concerns amongst practitioners in immigration law and may opaquely introduce certain biases into the decision-making process. Should such technology be considered as distinct from decision-making automated processes? Now, you'd mentioned during your presentation that you had some concerns about the human in the loop requirement and whether that's meaningful, and perhaps that is part of the answer to this question about whether the filtering technology like this, with the potential risk of introducing biases into decision making, whether that is problematic and should be regulated under directive or otherwise.
Yeah, well, I mean, the directive applies to decisions, automated decision making, but also to decisions that are, decisions that are assisted by AI. So you can have a human who is assisted by AI because information has been sorted or processed, or reports have been produced, so on. So that if it's an AI assisted decision, then the directive should still apply. And so it may then become, one of these, fine distinctions that get made as to whether it's just organizing information or it's actually AI that's assisting the decision, and, that sort of thing, to try and play games around it. But if information is being processed by AI in order to provide reports or statistics or profiles or whatever the case might be, then the DADM should apply to it. In terms of the human in the loop, though, there is first of all the issue of automation bias, and I think that's a really important one. If decision makers come to rely on the information that's provided by the tools, and to trust that information without thinking about what might lie behind it or what problems there might be with it or other factors that might need to be taken into account. If you have that kind of automation bias, then that's going to be a problem, and so your human in the loop is going to be contributing to the problem and not actually solving the problem. Some of the other human in the loop issues that I saw in a different context involve decision makers who were being asked. So you had machines producing a whole bunch of output, and decision makers who were just too busy to deal with it all, and so much more inclined to just rubber stamp whatever, or either accept it all or reject it all, but finding some way to manage their workload by just not dealing with it because it wasn't properly structured so that they could deal with what they were being provided with effectively. And so that can be an issue too if you don't have it carefully calibrated so that the human understands their role and has the time and resources to do the role that they're meant to do within that context. So there are a whole bunch of issues rolled into that.
Relatedly, Ian McKenzie asks, it would seem that lawyers not well placed to evaluate algorithmic bias, and that can be automation bias, I guess, or bias within the algorithm, and asks, is a community of independent experts developing that can provide independent advice and analysis?
Yes, and certainly the Directive on Automated Decision Making has its lists of peer reviewers that are required for different algorithms, and where those peer reviewers might come from. And they can come from universities, they can come from the private sector, they can come from a range of different contexts depending on what technology is out there. And of course, you can be sure that consulting companies are developing expertise in these areas as well, and we'll be happy to provide services in that regard. But certainly there is expertise developing around the review of algorithms. There's a lot of interest and a lot of research into ethical AI, into studying and understanding how AIs work. There's a lot of interest in addressing bias. And so certainly within the academic communities, I think there's a growing body of expertise on ethical AI and analysis of algorithms in those contexts.
Here's a question about the risk assessment levels, and whether you have any concern that these could permit extremely widespread but low-level human rights or privacy violations affecting thousands or millions, justified simply because the risk is evaluated as not serious enough to merit attention or mitigation. And that's a question about the definition of risk, and you might have potentially a very severe impact on one person, and maybe that would qualify as a severe risk, or higher up the risk assessment chain. But alternatively, you could have situations where you have a relatively minor risk, but because cumulatively the risk is spread out over thousands or millions of people, the question is whether that qualifies in the same way. I suppose the question is how exactly does the risk analysis function play out, especially when you're looking at multiple potential problems in individual cases.
Yeah, well, I mean, there's a couple of things that I would mention here. One is that there is this added feature with the DADM, which I think is interesting, which requires an ongoing review of results from automated decision systems. And this is something we don't have in administrative law. We have all sorts of boards and tribunals and decision makers that make decisions, and then nobody has the time, the energy, the research funds to go and do an in-depth analysis of decisions over the last 2 years, for example, from a particular board or agency, to explore or examine to see if there's a bias in a particular. Every once in a while, someone does a study like that, and it's really interesting, but it's quite rare. And so with these tools, you actually have under the DADM, you have this requirement to do an ongoing evaluation of those results. If that's done, and if it's done appropriately, it might actually give us some insight into whether there are flaws or problems with the decision making, and it might be insight that we don't otherwise get into decision making systems. So I do think that that's one interesting feature of the DADM that might have some benefit, particularly in the context of high volume decisions, because again, the reality is with a lot of the high volume routine day-to-day decisions that are made, people don't get reasons because there would be no right to reasons. You get your decision, most people just accept it one way or another because it's not worth the fuss to challenge it, and so that's it. It just happens. You're not going to go and seek judicial review of something that's relatively small or minor, and so there, it's possible that there might be more room for evaluation of outcomes and fairness under the DADM. I would hope that that data would be, publicly available so that researchers could also dig into it and look at it as well. But there is some potential there, and I think that's the other thing to keep in mind, that for some of these decisions, these low impact decisions, these are ones already where in our current system nothing happens, and it's unfortunate that there are also decisions, I think, that would be higher impact decisions where, because they have higher impact on less well-resourced people, that they don't get challenged near enough, because there aren't the resources there to challenge them, or the ability to challenge them. And so in the AI context, of course, that raises new issues about who's going to have the resources to mount a challenge alleging discrimination. And there are all kinds of issues about how difficult and complex and expensive that's going to be. So there's that piece, which I think we have to still come to terms with and work out. But on the other side, that, if this systematic review of outcomes, if the systematic review of outcomes is good and produces worthwhile results, that might be a plus.
The phone call, and it's nice that you have an old-fashioned landline, Teresa. We're talking about cutting-edge technological issues. We have about 5 minutes to run, and there are a lot of questions. I don't think we're going to get through them. We're going to conceivably get through them all. Is there anything there on the list that you can see that you particularly wanted to speak to? They're all very interesting. I'm sure we'd like to speak to all of them, but
I haven't had time to read through them, so I don't know. You can just reach in and grab something.
I think I try to run the questions to build on the conversation that we're having. One question is, what are your thoughts on the interactions between the requirements for an algorithmic impact assessment and a privacy impact assessment? Should they be combined, and would it be desirable indeed for the algorithmic impact assessment to be brought under the purview of the Privacy Act?
Yeah, that's a really interesting question on so many levels. So certainly the privacy impact assessment really goes to the personal data that are being used, and as part of an algorithmic impact assessment, there should be some sort of consideration of the data that are being used, and particularly with respect to quality, reliability, accuracy, bias, but also if it's personal data, the impact on the individual, the protection of privacy, and that's where the connection is to the privacy impact assessment. And I think that you would at least need both, or you would probably need both. Now, the oversight issue is a really interesting one, because we've got good oversight frameworks, good time-tested oversight frameworks for privacy that are in place, public sector, private sector, across the country. And we have nothing for artificial intelligence. And I've said in other contexts, I see, privacy, a lot of AI, attention to AI is channeled through privacy, in part because we have the legislative frameworks, in part because there's an overlap with data, in part because we have oversight, and effective and independent oversight. And so it becomes one of these things that is kind of, if all you have is a hammer, everything looks like a nail, right? So then you start to get these conversations shaped or turned towards privacy, because that's what we've got. And we're trying to get as much mileage out of it as we can, because we haven't got the other stuff. I think we need that other infrastructure. There are human rights issues that our human rights commissions are not adapted to deal with, or don't have the legislative tools or the resources, budgets to deal with. There are other issues that we have to deal with. So either independent oversight bodies for artificial intelligence, because the issues go well beyond privacy, or if we trust our privacy commissioners that much and the infrastructure, then more resources and broader legislative scope to bring more of automated decision-making under there. But in either case, we're going to need to have legislative action, because we're just, we're trying to make do and fix things as best we can, but we don't have, the infrastructure isn't there.
Well, I think that's as good a place as any to end. We're nearly at 12:50, which is our official end point. I'm sorry to those of you who asked questions which we didn't quite get to. I think we've at least talked around most of the issues that have been raised in the questions, and I hope I certainly learned a lot from Professor Scassa's presentation, and can only thank her for an excellent overview of the Directive on Automated Decision Making and the potential for administrative law to help to control the use of automation and artificial intelligence in public administration. I think it's clear that there is quite a bit of a ways to go, though, before we find ourselves in a place where we have a regime which is going to answer all of the issues of administrative law. And I mean, we're just scratching the surface because we're talking about administrative law. We didn't talk at all about the Charter or provincial human rights statutes, which are also important parts of the public law picture in Canada. So soft law and the directive are a step in the right direction, perhaps, but there's much more to do. And Professor Scassa signed off with a call for legislative action, and I think that's a call that many of us, perhaps all of us, can get behind. So it only remains for me to thank Professor Scassa for her presentation and for her fulsome answers to your excellent questions. The last in this year's Colloquium series will take place in 2 weeks' time on the 5th of April with Dr. Jennifer Cobb from the University of Cambridge, who'll be talking about judicial review and explainability, interpretability, human in the loop and delegation, and many of the issues that Professor Scassa discussed or touched on today, but from the perspective of judicial review specifically. So thank you all again for attending. I look forward to seeing many of you again 2 weeks from now. All the best.
Thank you, everybody, as well, and for your engagement. So many great questions. Thank you.